versus the state, case number S10G1085.
Gregory Rose for Florence, Joel Rivera for Adelaide.
Mr. Willis, you may proceed.
May it please the Court, I am Greg Willis here on behalf of Ms. Yeary. In regards to the question presented in my particular case, I know the Court directed me to go in a direction as it related to the actual Uniform Act and whether a witness was required or not. The basic premise, though, of my argument is that the inner workings of the machine and the source code is relevant and material and necessary, and I'm going to address that just briefly in order to kind of build on what Mr. Head talked about and also some of the questions that were asked by
Go ahead. Let me make sure I understand, because the issue in this case is whether or not you must subpoena a person in addition to the machine, and if you fail to subpoena a person, then you do not have access to the machine. Is that what the Court of Appeals decided?
That is what the Court of Appeals decided, yes, Your Honor, that's correct. But I think the basic principle under that, in order for the appellant to prevail, is that the source code must also be relevant and material and necessary.
Can I ask you, Mr. Willis, the previous case and this case, are they in such lockstep that a ruling in one is controlling in the other?
I do believe that is the case, Your Honor.
Why? I don't understand why that's the case. I mean, the other case is about whether on a particular set of facts a subpoena meets the material and necessary test. Your case is about, I took your case as basically assuming that it's material and necessary. Do you have to subpoena a witness as opposed to just subpoenaing documents?
And I agree with that portion. My response to that was related to relevance and materiality, is that they would be lockstep together as a ruling from this Court on materiality and relevance. But I do think there's a procedural difference in the two cases where the Court can come with a different decision in the Davenport case than in the Yeary case.
Did the Court of Appeals decide the materiality issue?
The materiality issue was not addressed by the Court of Appeals in the opinion.
So we could reach that first issue and never deal with materiality, the issue of whether or not you have to subpoena a person. End of case, could we not?
I agree with that.
Because that's the issue we asked to be argued. Anyway, we're not trying to restrict you. We just want to try to get the lay of the land here.
I understand. I will move quickly. The couple points I'd want to make is that the expert, Mr. Workman, who also testified in the Yeary case, testified uncontradicted. The state's had many opportunities to call in an expert to contradict his testimony about the programming and the necessary aspects of it in order to test it. That was not done and has never been done that I'm aware of by a computer expert, someone certified as a computer expert. The other issue about relevance is that defense cannot get a Georgia machine with Georgia programming. CMI will not provide that to anybody, so any testing we can do on an Intox 5000 is going to be testing that will not necessarily correlate with an Intox 5000 with Georgia programming. As it relates to the issue in this case, the trial court in our case, at the motion, we were actually talking about the steps of going through necessity and materiality and relevance. And the trial court specifically asked me, and Mr. Workman, to jump through the hoop of relevance first. In other words, I started to explain to the trial court that if we get beyond relevance, then we're going to need to go to Kentucky. And I was explaining to her that we already had a lawyer employed in Kentucky working on other cases. The trial court specifically asked at that point in time that why don't we jump through the hoop of relevance first, and then once that is decided, we may need to go to the further steps. And that's specifically in the actual hearing prior to Mr. Thomas Workman testifying about the relevance and materiality of the source code in this case. The trial court in this case also found that the source code was not relevant and material and did not make a finding as it related to the manner in which the Court of Appeals ended up ruling in this case, where the Court of Appeals held it was a procedural failure in that a natural person was not named in regards to a subpoena.
Well, now that's a concern, is that the appellate court ruled on an issue that was never raised at the trial court, or was it raised at the trial court?
It was never raised or mentioned at the trial court level. Mm-hmm. In fact, the trial court's order specifically held that the testimony about the source code did not prove to her relevance and materiality. Despite the fact that it was uncontradicted, the trial court ruled in that manner and did not make any ruling in regards to the Uniform Act and what would be necessary to go to the next step. So we never got to that point of getting the subpoena, the authorization for the subpoena issued. And there's an interesting case that's almost 100 years old. It was actually argued 100 years ago and about 1 month from now, one month short of that. It's the Wilson case, which is cited in the brief. And the issue in the Wilson case was that the subpoena was directed to the corporation. And the Supreme Court of the United States held that it was proper to direct a subpoena to a corporation, and held that in those cases that you did not necessarily need the testimony of a natural person, that the actual corporation could send an agent, could deliver the information, books, tangible evidence, and other things, and upon delivery of that, they may not necessarily need to testify. Now, the court also held in that case that they could be needed to testify. Subpoena duces tecum stands for both propositions.
Now, Wilson that's 100 years ago.
That was 100 years ago. It was argued March 2nd and 3rd, I believe, of 1911.
Okay.
And this reasoning is persuasive today. It's an extremely comprehensive argument because it was dealing with whether a subpoena to a corporation is appropriate or not. And the Georgia courts have adopted this. In 1959, there's a Jones case where the Georgia courts adopted that reasoning, and there have been many cases since then where a subpoena has been held valid where it actually goes to a corporation, and a corporation is named as the entity.
So you've got two cases. You've got Wilson, 100 years ago, said you didn't need a person. And then you've got a Georgia case 50 years ago that said you didn't need a person. And yet the Court of Appeals said under the statute you have to have a person.
That's right, Your Honor. And there have been many cases since 1959. I'm just going back to history because that's important when the Wollison case was decided. In the Wollison case, the Georgia courts determined that the Uniform Act, which is what we're talking about, which we requested a subpoena under in this case, the Uniform Act also applied to a subpoena duces tecum. And the reason that they held that, or at least the reason they gave, was that it would border on the absurd not to allow someone to be subpoenaed to bring records to court if they could subpoena them to actually come to court themselves from out of state. The important part of that is nowhere in the code, in the Uniform Act, does it mention a subpoena duces tecum. It never explains the requirements of it, never explains how it must be completed, and there are no explanations in the code section or even a mention of it. So the Wollison case actually expanded the Uniform Act to include a subpoena duces tecum. What's also
the whole problem that gave rise to the Uniform Act was the difficulty in getting a person from out of the state to testify. And it seems as if that was the direction going with the passage of the Uniform Act, so states could get witnesses from other states to testify.
Absolutely. And that, of course, was dealt in many cases in Georgia before when persons were complaining about their constitutional rights to compulsory process when the state didn't have a means of doing that. And now with the Uniform Act, we do have those means, but obviously we need to go through the Uniform Act to require folks to attend.
Mr. Wood, in your case, you subpoenaed documents, right? Not a person, right?
That's correct.
Now, I guess I'm just an old practical thinker. When you get to trial, how do you get something in evidence if you don't have somebody to lay a foundation? I mean, what good does it sometimes say, I get several documents. How do you get them in evidence?
Well, Justice Hines, to begin with, I never got the point of the judge authorizing the subpoena.
Right, I understand that, but if you were going to then lay a piece of paper, I guess, on a person, right?
Well, what I was going to do, Your Honor, is I was going to identify the agents of CMI, whether it be Toby Hall, the president, or Braswell, or...
You're going to subpoena him or her or whomever, right?
That is correct.
Okay.
And that was the holding of Wilson also, is that regardless of who the subpoena is directed to, the corporation or a person, a natural person is going to respond. It doesn't matter the actual name on the subpoena, whether it's a corporation or not. The natural persons that are responsible for the business affairs of that corporation would have to answer for that subpoena. And if they did not answer for that subpoena, the natural persons would be the ones that would be held in contempt. So, and that was part of the dialogue in Wilson explaining all of this back in 1911, because that was some of the discussion as far as the director and owner trying to avoid answering questions and providing documents under certain privileges. So we never got to the subpoena process in the Yeary case because the court ruled before that those next hoops were addressed that the source code was not material or relevant. So we never got to the point of asking what particular persons needed to be subpoenaed, how the order was going to be crafted, and those things. And that was part of what I was discussing with the judge when we, at this discussion prior to the relevance hearing, was that there were some very complicated matters that needed to not only satisfy the trial court in Georgia, but we were also needing to satisfy lawyers in Kentucky for what they were trying to accomplish as far as getting it done there.
With a major corporation where it may not be easy to identify who a particular records custodian, if you have to subpoena an actual person, aren't you left having to subpoena the president or somebody you know has authority over everything in the company?
And that's part of the problem that was the foresight of Wilson 100 years ago that it was addressed and discussed, is that it's almost impossible with a multi-layered corporations, different names, different states where these things are ongoing. You could certainly subpoena one person in one state. They could arrive, travel down, and then come in and say, I don't have what you want. We don't even have that in that state. That's located in a different place. And that is one of the technological challenges that I indicated in the brief that certainly makes it much more reasonable to actually subpoena the corporation and allow the corporation to determine who should actually answer that subpoena and respond to the subpoena.
Do you think if you subpoenaed the CEO and the corporation said, no, we're going to send you somebody who can authenticate the documents you requested, would you be able to require the CEO to show up just to authenticate documents? Or is all you get basically a records custodian?
Well, I think that I believe that what the corporation will probably do under those circumstances is file a motion to either substitute someone to take the place of the CEO that could authenticate the documents, and we would certainly accept that, or we would be in a position, as we are in this case, where we didn't care who arrived. My client, our only concern was to get the source code to allow Mr. Workman to analyze it through the defragmenters and through his programming to determine how it's analyzed. And that was the entire point of us requesting this source code, was to have it analyzed. So the actual person bringing it or sending it or emailing it is not relevant to our particular question. And that's also why in the motion hearing as it related to relevance, we did not address a particular person, because as the Wilson case spoke of, there are many times the person is nothing more than a depository that knows nothing of what they're delivering. That's exactly the case in our request. We are simply requesting the source code for analysis, so it doesn't matter whether it's the CEO or a keeper at the computer lab or someone else. It just did not matter as it related to relevance who we requested to.
Help me along this front. Since the statute does not mention documents, is that correct?
That's correct.
The Uniform Code does not mention documents. And the Court of Appeals basically says since it does not mention documents, then it must be addressed to persons. It seems to be that.
That's correct.
Even if we ruled in your favor, then you still have not crossed that materiality threshold, have you, according to the trial court? And what would happen even if we ruled in your favor?
I think it would be remanded to the Court of Appeals to make a determination of
underlying materiality.
Unless, of course, it was decided in conjunction with the Davenport case, which I think could also be done as it relates to materiality and relevance.
But now, and what you're saying, though, the Court of Appeals, because that question hadn't been decided by a trial court, it would have to be with direction to remand to the trial court, wouldn't it, to hear that issue?
Justice Hines, the trial court did rule on the relevance. That's the only issue that the trial court ruled on as it related to the out-of-state subpoena request or the authorization request for the out-of-state subpoena. So the trial court did rule on that one issue.
Okay.
But to get us to where you want us to go is you want us to rely on the Wilson case and the other case that was cited in 1959. That's how, the Jones case. You want us to rely on those two cases to get us past this person issue.
That's correct. And Justice Benham, the reason I quoted those old cases and brought those to the Court's attention is because when the Court in Georgia adopted Wollaston and explained Wollaston and held that the Uniform Act was sufficient for a subpoena ducis tecum, that's what the holding of Wollaston was. At that point in time, the subpoena ducis tecum had been defined for years, since 1911 by the Supreme Court of the United States and also 1950s by our Georgia courts. So the rulings of those courts, I think, fall into place with Wollaston. And when they adopted the subpoena ducis tecum as available to the Uniform Act, I think they also adopted the same principles that apply, which is that you may require the person to come testify, you may not require them to come testify, or you may require both the production of the evidence and them to testify. It just leaves it wide open, according to the case law in both the state of Georgia and the U.S., that that subpoena can be used for either or both. So if you take Wollaston being decided in the year 2000, many years after all the precedent of what a subpoena ducis tecum is, I think that the clear holding of that case should mean that we are sufficient by notifying the court that CMI is the entity that we're looking for the information from. I also think that the logic of Wollaston is clear. The logic that you should also be able to require someone to come into court and bring documentary evidence is also very logical as far as where society is going with technology. So we should also allow folks to provide these things without a witness coming to court. So I think the next step is if we take Wollaston, Jones, and Wilson together, then it certainly would, in my opinion, allow us to have documentary evidence, tangible evidence, supplied to the courts without necessarily having witnesses there. The other thing that's interesting in one of the cases cited in Wollaston and the brief also, the lit, it reads that, indeed, the power to compel a witness to appear and the power to compel production of documents both are critical and fundamental to the evidence-gathering process, especially where the target of an investigation may be subjected to criminal charges based only on the naked, unsubstantiated testimony of a witness who actually may possess documentary evidence inconsistent with his sworn testimony. And that's important in this case because the machine may be spitting out a number saying that someone is guilty of a DUI, but there also may be documentary evidence, source code evidence in that machine where an expert could say, look, the machine is making errors. It's incorrect for this particular defendant and incorrect for this particular defendant under these circumstances. And I think that's an important issue in this case that the courts had already addressed at one point. The other 2 points I would like to make about the issue as it relates to the failure to name a person, all of the courts have determined that a natural person must act and respond to a subpoena. So regardless of whether the subpoena is to a corporation, a natural person is going to have to respond to it. So I think that even the Court of Appeals is incorrect in assuming that a natural person is not being subpoenaed, because technically someone would have to respond to that. The other issue that the Court of Appeals addressed are fundamental rights. The Court of Appeals basically held that my client had waived her fundamental rights. When we requested compulsory process, we had a hearing on it. We objected at the actual stipulated bench trial. that my client had not waived her fundamental rights, was making an objection based on the compulsory process rights. So she did not waive.
There is no compulsory process rights beyond the jurisdiction of a sovereign, right? So the state of Georgia doesn't have any right to make any other state provide witnesses or documents.
I think with state action, if the state actually denies, such as the court actually denies that subpoena to go to the foreign state, I think that's state action that is
Under the statute.
That's correct. And that is different than what we had prior to the Uniform Act.
Your turn.
Thank you, Counsel.
Thank you.
Nazaire?
Good afternoon.
Good afternoon.
May it please the Court, my name is Joelle Nazaire, and I represent the appellee of the State of Georgia, and it is an honor and a privilege to be among you here this morning, or this afternoon. Your Honors, the issue before the Court today is a narrow one. There was one question presented, and that is, may a party make a standalone request for documents under the Uniform Act to secure witnesses from without the state? And here, in this case, obviously, the State of Georgia. And the answer to that question, quite simply, is no. And the statute, the actual act, as well as the cases, bear this out. You could actually answer this question about whether or not a party in a criminal proceeding can make a request just simply for documents under the Uniform Act to secure attendance of witnesses from without the state without ever having to talk about the source code. This question has been raised for quite some many years, and in fact, the Uniform Act, as it reads presently, was formulated in 1936 by the National Conference of Commissioners on Uniform State Laws. That happened back in 1936, and I believe that was when they were conferring back in Boston, Massachusetts. That is some 25 years after the 1911 case that the appellant is citing, which I believe he mentioned was the Wilson case. Some 40 years later, in 1976, the Georgia Assembly then also adopted or enacted the Uniform Act to secure the attendance of witnesses from without the state, and that is essentially delineated in Section 2410-90 et sec.
Ms. Nazaire, I believe Justice Benham asked Mr. Willis, which cases you're relying on. It says Wilson and I believe Jones and maybe the other case here. Are you saying those cases do not stand for the proposition asserted by Mr. Willis, or do you say they are not applicable, or what is your argument regarding those matters, please, ma'am?
Yes, Your Honor, and thank you for that question. What I wanted to bring to the Court's attention is that the first case that was cited by Mr. Willis, the Wilson case, predates the enacting of the Uniform Act to secure witnesses from without the state. In fact, as I read that particular case, the Wilson case makes no mention of securing witnesses from without your jurisdiction. In fact, that particular case focuses primarily on being able to subpoena a corporation. It doesn't address the issue of whether or not an individual can actually subpoena witnesses from without their jurisdiction.
No, but it stands for the proposition that you can subpoena, even though corporation is an artificial thing, you can subpoena it, and either the corporation will provide you documents or they'll send a human being on behalf of the corporation.
Yes, it does. It does mention that, Your Honor, Justice Namis, it does mention that. However, I would ask this Court to distinguish that, because with respect to this particular narrow issue, and also as it was applied to the case on the trial court level, that particular case, that 1911 case, is different. I would also like to bring to your attention, there was a case that was decided by the United States Supreme Court in 1959, and that was also cited in my brief, and that's New York versus O'Neill. And the Supreme Court of the United States in that particular case, again, that was New York versus O'Neill, that was decided in 1959, some 48 years after the case cited by Mr. Wilson. It described the Uniform Act to secure witnesses from without the state as a catalyst of cohesion. And ostensibly, they described it this way because the act should be interpreted by all the states that enacted it the same way in order to protect the rights of the person who you are calling to testify from outside of your jurisdiction. Also, Your Honors, if you look at...
And what is the majority rule under the Uniform Act on whether or not you can subpoena documents from a corporation? I mean, if we're looking for cohesion and uniformity, what is the uniformity that's out there?
It appears as far as corporations, it's difficult to actually find a case law with respect to just corporations. The cases that we have been able to find indicate, for example, that an individual, if a corporation is being, or the president of a corporation is under indictment, for example, that the president of the corporation or the CEO of the corporation can also be commanded to bring in documents with respect to that corporation. And I believe that that was one of the cases that the appellant had cited, and I indicated in my brief that the reliance on that particular case was misplaced. I believe that was the Wollison matter. In fact, that particular witness that was called to the grand jury was in fact a material witness, was in fact a necessary witness, and the court had basically indicated that that person could absolutely be compelled to bring forth documents as well.
And do you have any problem with that holding, that even though subpoenas for documents are not expressly discussed in the Uniform Act, that the Uniform Act suggests that if you can subpoena witnesses, you can also subpoena documents?
I think that by extension you can, as long as you satisfy the most minimum requirement under the Uniform Act.
Well, there are all kinds of other requirements, but that general idea that if it's material and uniform, you say you can just get documents, you don't have to, you can get documents in addition to witnesses. That's what Wollison said.
There must be a witness. That is correct, Your Honor.
What point would there be in a corporation, I mean, under the rule you suggest, instead of just subpoenaing Bank of America in Charlotte, North Carolina, you'd have to subpoena, if you couldn't figure out who the record custodian for, an account in the Virgin Islands was, you'd have to subpoena the CEO of the Bank of America. Then the corporation would presumably say, we're not going to send the CEO, he's too busy, we want to send the record custodian that we've identified in the Virgin Islands. I mean, why would the act be construed in that way?
Your Honor, might I suggest that if the person that is seeking a witness is able to certify in two courts, the court in the demanding state as also the court in which the witness resides, if two courts are able to certify that that particular witness is necessary and material, then that particular witness would have to be called in to testify. But might I also suggest that the person who's making the request do their due diligence in order for them to figure out who that necessary and material witness is before trying to seek a certificate from the court at the trial level. If someone finds himself in that position, they would have to undertake find out how or who that person should be for them to testify, rather than just sending a blanket request for a records custodian or a blanket request for the CEO of a corporation.
But let's say they do that. They do due diligence on this corporation that is apparently very resistant to providing anything, and they can't figure out the name of the low-level person who works in the records room. So they've done their diligence, and they say, well, the one person we know controls all the records is the CEO. So now we're going to put on our subpoena the name of the company, but we'll put the CEO's name above it because that creates a person. Why would that be a logical rule?
Your Honor, I'm not suggesting that that would necessarily be logical in the scenario that you just outlined. My suggestion would be that that person, whoever is named on that subpoena, before they could even get a subpoena, a court has to certify that that person is a material and necessary witness. And in order for any name to be on any subpoena to a person outside of the jurisdiction of the state of Georgia. So if a court did find that the CEO perhaps or the record custodian is a necessary and material witness, then that could be challenged perhaps in the state where that particular witness resides.
Ms. Nazir, Mr. Willis gave us his best authority for his view of the case. What is your best authority for your position? A case or anything? What is your best foundation for your argument, you believe?
The best foundation, if I just may bring the Court to the Supreme Court of the United States, People of the State of New York versus Joseph C. O'Neill.
The O'Neill case?
Yes, that's one case, Your Honor. And I would start with that case because it's a United States Supreme Court case which essentially described what the Uniform Act to secure the witnesses from without the state is, and essentially why it was promulgated way back in 1936. I would also bring the Court's attention to Magnus versus the state, which basically indicated that the person making the request for the out-of-state witness has to establish sufficient facts in order to satisfy the judge in the demanding state for that particular witness. Also, and Mathis was decided in 1979.
But when you're talking about documents, the only question of materiality and necessity would be that the documents are material and necessary, and that the human being can get you the documents, can authenticate the documents, right? You wouldn't have to be showing that the CEO, is going to come testify himself about matters beyond the documents.
That is true, Your Honor. With respect to the actual documents, they would have to be, ostensibly, they would have to be material and relevant as well. And certainly the individual, for example, the records custodian, whether it's the records custodian or the CEO, that would have to be a necessary and material witness. I think it goes without saying that if it's simply a document that has to be entered into evidence, you would have to have the records custodian in order to enter that particular document into evidence. But it seems as though when the Uniform Act was first promulgated back in 1936, it appears as though the legislative intent was to secure the presence of an actual person whose testimony is required in a criminal proceeding. And we can also see that in 241091, which is the definitions section of the Uniform Act as it is enacted by the state of Georgia. And it clearly indicates in 241091 that the witness is a person whose testimony is desired in a criminal proceeding.
Well, I guess what I don't understand is why would you want to make this argument that you have to subpoena an actual person? If I'm in a corporation and I get a subpoena for documents, I could say, well, no, I don't have to supply those documents. You have to subpoena an actual person. Then when I get an exchange, it's a subpoena for an actual person. Now I got to get on the plane and go to Georgia. What's the advantage of doing that? Why not have the flexibility?
Because the Uniform Act, as it reads, it doesn't appear to give the flexibility of simply sending a subpoena to a corporation.
I'm trying to figure out what the rationale might be. What's the rationale for this?
Well, it's because it appears as though the Uniform Act is to have a witness come forward and testify and to afford that particular witness protections. And all of those protections are also contained within the Act. And
I guess the question is where supplying documents would be just fine. All they want is documents. What's the rationale for having a live body there to say, here you go?
Because that is what the Act is. That's what the Act requires. If you look at the
rationale, because that's what it requires. What's the thinking? Is there a policy behind it, or? I
don't think that there's an actual policy behind it. I think the thinking is that when the statute was enacted, what the intent behind it was. And if you read the cases that have interpreted it, and if you look at the reason why it was established in the first place, it was in order to compel individuals from other states to testify, whether it's a grand jury proceeding or a criminal trial. And oftentimes someone may decide that they're going to move out of state in order to avoid a subpoena from another state. And the Uniform Act might I suggest, is an enabling statute so that you can get the testimony of that out-of-state witness. I think what's happening here is that in the context of a driving under the influence case is that the particular piece of information that they're looking for, which is the source code, is housed in Kentucky. And the only way to get that particular source code, which in this particular case was never found to be material, relevant, or necessary, it appears as though the appellant has tried to avail themselves erroneously to the Uniform Act to secure witnesses from without the state.
Help me with this if you finish Justice Melton's question.
Yes, thank you.
Does Georgia stand alone in being the only state that has decided you must subpoena a person and you cannot subpoena documents alone? Has any other state ruled that way?
We have not seen, nor have, I have not cited, nor has appellant cited a single case from these United States of a state saying you must not subpoena, you cannot, you must have a witness, or you must not just simply subpoena the documents. There is not a single case from a Supreme Court or a Court of Appeals indicating that you can just simply subpoena documents. In fact, our Court of Appeals has said that you cannot simply subpoena documents.
Well, in this case, right?
In this particular
but
case, Your Honor.
You're saying there are no cases either way?
I have not found cases either way, and which is why when I started my argument that I want to bring the Court's attention to the fact that the issue here is relatively narrow, in that the question is, can you make a stand-alone request for documents, and there's nothing to suggest that you can.
But there's nothing in the statute to prohibit it.
There isn't anything in the statute that says that you may not. However, the statute clearly delineates the requirements in order to have an individual come before a court outside of their jurisdiction. And again, the Act has a definition portion to it as well, which is 241091. And 241091, subsection 4, clearly defines witness, which means a person whose testimony is desired. There isn't anything in the statute that says that you can simply subpoena documents availing yourself to the Uniform Act to secure witnesses from without the state.
I guess, for me, it comes down to whether when you subpoena a corporation as a witness to bring documents, can you just subpoena the corporation or subpoena the corporation and write records custodian above it, or do you actually have to identify a particular individual at the corporation? Why not just assume that if you subpoena a corporation, you can subpoena the corporate entity, and the corporate entity can decide what human being is going to be the human witness?
And I do understand your question. And the best way to answer that question, Justice Namis, is because that's not what has been, that's not how the Uniform Act should be interpreted. Essentially, the way the Act reads and the way it was intended way back in 1936, it doesn't appear as though the Act was intended to simply have an individual subpoena the records custodian from another state in order to have some documents in their criminal proceeding at the trial court level.
Is there anything in this Act that would prevent us from interpreting it in such a way that you would not have to subpoena a person?
Yes. In fact, I would bring the Court's attention again to 241091, which is the definitions portion of the Uniform Act. And the definition portion indicates that a witness means a person whose testimony is desired in any proceeding or investigations by a grand jury in a criminal action.
But when a witness for a corporation shows up, they're not really there as an individual. They're there as a corporate person, right? I mean, you're not subpoenaing them individually to steal the documents from their company and bring them to court. You're bringing them there because a corporation can't show up in court without a human being.
Yes, and again, if the person that is making that request, that's availing themselves to the Uniform Act to secure witnesses from without the state, then they would do their due diligence to find out who that person is. If it is in fact a record custodian and the person making the demand can go before the trial court and say, I need the records custodian from the state of Texas, for example, or the state of California, in order to admit these necessary and material documents, and that is certified in the demanding state, and then it's also certified in the state where those documents are held, then perhaps. However, that wasn't done in this particular case, and my message is also that, thank you very much for your time.
Time is up, counsel. This court will stand recessed until 2 p.m.
All rise.